Mendez versus State.
Good morning, Your Honors. May it please the Court. I'm Terrence Kehoe, appearing on behalf of the appellant Francisco Mendez. This time I'd like to reserve 3 minutes for rebuttal. Mr. Mendez was convicted of capital sexual battery and lewd molestation and is serving a life sentence. He is entitled to a new trial due to the erroneous admission of collateral act evidence. Our assertion in this appeal is that the trial court abused its discretion when it admitted collateral act evidence in this case.
What do you consider to be your strongest argument?
Well, I think there's several strong arguments. Number one,
you know what? Lawyers always answer that question that way.
Well, I hope in this court,
even if there's a scintilla of difference between them, try to identify your strongest argument for them.
All right. McLean case talks about the analysis that the judge had to go through. And even though the McLean case came out about a week after this trial occurred, much of the same factors that were in the McLean case were argued in the pretrial motion for hearing. Essentially, two things in McLean. One, that the evidence of the prior collateral act, there has to be clear and convincing evidence that this prior collateral act occurred. And I don't believe that that's met in this case.
All right, let's talk about that for a minute.
Okay.
The victim in the prior act clearly gave sufficient evidence to create a jury question that a crime had been committed. Did he not?
A crime, yes, because he alleged that somebody touched his genitals.
Right. Okay. So really the focus is on whether or not the identity evidence was sufficient. Is that right?
Right.
All right. So now we're in apparently this is a camp that's out in the woods somewhere. It's a remote location. Is that right?
Yes.
There's only 3 adults that are working in the camp on the night that the crime occurred. Is that correct?
Well, you're assuming that a crime occurred, but I understand you're talking about
now we're talking about identification. I thought you and I already agreed that there was enough evidence that a crime occurred because the victim said that a crime occurred. He testified that he was fondled on 3 occasions.
Right? I agree, but there were certain things that made that not necessarily a credible statement. I agree that he testified that he was touched.
Well, I mean, in the run-of-the-mill prosecution, if they were charging your client with the first incident and they were going to trial on that, to have a victim come in and say, I was touched on 3 occasions without my consent and my genitals, ordinarily would create a jury question, wouldn't it?
I agree with that.
Okay, well, let's talk about the identification. They're out in the woods in a remote location. There is only 3 adults there on the night in question. Is that right?
Correct.
Okay. One of them's a woman.
Yes.
Okay. So now it boils down to two men who could have committed the crime, right?
Well, the individual never testified, the complaining witness never testified the person that touched him was a male or a female.
Okay. All right. So it could have been
somebody who he could not identify touched him.
Okay. Well, Mr. Collar testified that there were 3 counselors working. The woman was asleep on the night in question, and that your client left the bunkhouse that they all shared, and he was gone for a sufficient length of time that it caused Mr. Collar to get out of bed and go looking for him, right?
Well, after the fact, Mr. Collar testified that on the night in question he got up and was looking for Mr. Mendez and saw him in the hallway. He saw Mr. Mendez do nothing wrong. Mr. Mendez was a senior individual there on the site.
He saw him wearing the hat, though, the same hat that the boy had identified.
Well, it's not necessarily the same hat. That's what the state wants to argue, that it's the same hat.
Well, the boy said it was a cone-shaped ski hat. Mr. Collar said it was a Robin Hood type looking hat.
A little ski cap, doesn't remember color, like a Robin Hood hat. But that doesn't mean that it's the same hat. That's not an identification of a hat. And Mr. Mendez testified that he didn't wear a ski cap.
Didn't the boy also testify that he recognized the hat because he had seen Mr. Mendez wearing that hat, and that Mr. Mendez was the only one that wore that hat at that particular camp?
He testified that he believed it was Mr. Mendez because Mr. Mendez wore that type of a hat, that he had seen Mr. Mendez with that type of a hat.
Did he also say Mr. Mendez was the only one that he had seen in that camp wearing that type of hat?
That was the boy's testimony. There's nobody else's testimony like that. Mr. Collar says that Mr. Mendez wore a Robin Hood type cap.
He saw it. Mr. Collar said he saw him with it that night wearing the hat.
Well, Mr. Collar doesn't remember dates or what time it occurred. After
the night before, he relates it that the night before the boy reported the incident, he saw Mendez out late at night. He left the cabin. He was gone for a long period of time. Collar went looking for him, and when he found him, he was wearing the hat. Doesn't Mr. Collar say that in his testimony?
Well, he testifies that he became aware like 2 or 3 days later that he testified. But essentially, what you say is correct, Judge. That he said that Mr. Mendez had a pointed cap.
Right, and he was wearing it, but he was able, because the boy reported it the next day, Mr. Collar was able to, in retrospect, relate back to the night in question, and he clearly identified the night in question and said this is when he went out looking for Mendez, and he found him, right?
He found him in the hallway,
Okay.
where he legitimately supposed to be.
And he asked Mendez what he had been doing, and Mendez said that he had been checking on the boys. Is that right?
Yes, he testified that. Well, that's what Mr. Collar said. He said yes.
Okay, so apparently, I mean, if you draw some reasonable inference from that, either Mr. Mendez is the perpetrator, or he was in there at the same time the perpetrator was in there.
Well,
because the perpetrator came back three times on the same night to the boy's room and followed him, right?
Well, and then you have to factor in that this boy who alleged that these things occurred is in a hallway, in a room off of a hallway with 2 or 3 adults just down the hallway, and he alleges that 3 times somebody came into his room and touched him, and he never got up and reported it to any of these adults. And you have to, he comes from a house of abuse. Did this actually occur?
Mm-hmm. And I guess the final point that Mr. Collar made was that after he heard Mendez's explanation as to what he'd done, and then he reflected on it for a couple of days and found out about the incident, he recalled that Mr. Mendez did not have a flashlight with him, which would have been unusual given what Mr. Mendez said he was doing, checking on the boys in the middle of the night in a remote location, right?
At the time that he encountered Mr. Mendez was in a lighted hallway.
Okay.
So the fact that Mr. Mendez at some point had checked on the boys doesn't mean that when Mr. Collar finds him with without a flashlight at some other point in time. So Mr. Collar went out, was looking in the outside to determine if Mr. Mendez had gone outside or some other things like that. And
can identification of a defendant be proven by circumstantial evidence, or must there be direct evidence?
No, it can certainly be proved by circumstantial evidence. It happens all the time. But I think back to the Zerbe case where the court, 4th DCA, and this is a McLean issue, said that there was a conflict in the evidence concerning his collateral act evidence, and therefore it wasn't clear and convincing and shouldn't have gone to the jury. Here we have a clear conflict in the evidence. And there's
well, that Zerbe case, the 4th District held that there wasn't even enough evidence of the charged crime, right?
Well,
before you even got into the collateral crime, they said that it should have been a DV on the charged crime, right?
Now, they said it should have been DV'd on the child abuse charged crime. They remanded for a new trial on the lewd molestation crime in Zerbe. And yes, the 4th DCA in Zerbe did, it essentially went down the McLean list and found that it violated virtually everything that occurred in McLean. It wasn't clear and convincing evidence that a collateral act occurred. and there wasn't, it wasn't relevant, it didn't go to prove any issue, and it didn't meet the balancing test and all that. I talked about two things in McLean. First was the collateral act evidence and whether it was proved by clear and convincing evidence, and we talked about that. Second is, of course, the balancing test. Essentially, the court says that even though we have this new statute that says in child molestation cases, prior acts of child molestation.
Let me ask you about that. We should look at the facts in McLean because the Supreme Court allowed the use of the collateral crime evidence in McLean, right?
Yes, I mean, that's clearly.
I mean, that's our poll star. We need to compare the facts in McLean to the facts in the instant case, and look at the test that they outlined, which had to do with the similarity of the acts, the closeness in time, the frequency of the prior acts, and all of that stuff, right?
Correct.
All right. So let's compare the two of them just for a second. And first of all, in the McLean case, there was a 14-year span of time between the charged act and the collateral act. Is that right?
A large amount of time.
Right. So that would cut in favor of the defendant very substantially. The fact that there's 14 years that intervene, right?
Yes.
So apparently, the instant case is more favorable to the state on that factor.
I agree, but McLean, the key point in McLean is there's penetration of the anus in both the collateral act and the charged crime.
Well, I mean, in McLean, on the one case, on the charged case, there was one incident of penetration of the anus with a finger.
That's
and
right.
In the collateral crimes, there was 4 occasions, one of which involved penetration of the anus with the penis. Another incident involved rubbing the penis on the back. Right? No, I got my facts wrong?
I think that what the trial court allowed 2 of the 5 collateral acts into evidence.
All right.
Okay. The 2 that occurred that they allowed in were at the victim's house. They didn't allow in the camping trip, the one at the victim's farm, and the defendant's house, because McLean says the trial judge only allowed in evidence of collateral acts, 2 collateral acts at the victim's house.
Okay, so we're comparing penetration of the anus with the finger in the charged crime and penetration of the anus with the penis in the collateral crime.
That's correct.
And those are sufficiently similar according to McLean, apparently.
Correct.
And in our case, in the charged crime, we have fondling the penis and putting the mouth on the penis. And in the collateral crime, we have fondling the penis. Right?
Yeah, yes. I mean, unspecified touching the genitals.
So we're supposed to reach the conclusion that as a matter of law, in this case, the manner of committing the crime is so dissimilar there that it doesn't satisfy the McLean test.
Well, you have different locations, different age of the children, different contexts. One, the defendant is a sole adult babysitting 2 children in a home. The other, he's one of 3 adults supervising.
Well, in McLean itself, the ages of the children were different, right? In McLean, the ages of the children were different. The victim in the charged crime was 8, and the victim in the uncharged crime was 12, right?
You're right.
It's just a more dramatic difference here. It's 6 to 13 or 7 to 14.
That's correct.
Depending upon the evidence, right?
That's correct.
What do you make of the fact that in the instant case, the relationship between the defendant and the victims is very similar in that the defendant was a counselor in one case at a camp, another case at an aftercare center, and that's how he met the victims, and he was in a kind of a custodial authority over the victims. Do you think that's one of the additional facts that would militate in favor of finding that the crimes are sufficiently similar?
Well, I think it's more dissimilar. In the one, he's a private babysitter hired by a parent, and the other, he's hired by the state to be a camp counselor at a DCF-run facility. But
in McLean, the victim in the charged crime had a familial relationship with the defendant, and the uncharged crime had no familial relationship with the defendant, right?
Right, but both times the defendant is visiting the father's house or adult male's house when the both times the defendant is a visitor in the home of an adult male friend and does something inappropriate to that person's child or grandson or something like that.
Counsel, I just think that you and I are splitting a lot of hairs here trying to analyze these two cases, and it seems to me that this is the type of situation that we entrust trial judges to employ the balancing test, and the judge here did employ the balancing test, and we have to find an abuse of discretion here, don't we?
Yes, and I know my time's out, Judge. I need to just...
That's all right, I'll give you some more.
Okay.
The only
First of
fair
all,
thing to
McLean,
do.
he admitted it.
Corky's had a lot of it.
First of all, McLean, he admitted the collateral acts, which changes the whole complexion of the admission of the collateral acts about whether or not the trial court can be sure that the collateral acts meet the level. But yes, we're dealing with an abuse of discretion. We have there is significant question in this case about whether the prior collateral act ever occurred. He was never charged with it. It is 7 years after the fact the 20-year-old comes in and testifies that somebody who he can't identify touched his penis on one night. And on the other side, we have the 7-year-old boy who the defendant babysits for over a significant period of time, who says that the defendant essentially touched him and performed oral sex on him, and in his home with his sister present, and that this first act, which is 2 and 3 years earlier, different setting, different situation, is supposed to somehow corroborate. It's absolutely propensity evidence. There's no issue in the case that it goes to, and in this case, the trial court abused its discretion. Thank you for the extra time.
I'll give you some more for rebuttal.
May it please the court, good morning, counsel. My name is Kelly Neal, and I'm here on behalf of the state of Florida. Judge Torpey, you pretty much have summed up the state's position in this case.
That doesn't mean I agree with you.
I understand that. But I can stand here and repeat everything you've just said, too.
Well, this was done before McLean was decided, was it not?
Correct.
Right. Under McLean, what was the trial judge's obligation?
Under McLean or prior to McLean?
No, under McLean, what did the trial judge have a duty to do?
I think it's just with any similar collateral fact evidence. I mean, even just a straight Williams rule case. I don't think that McLean tightened the standard on child sex abuse cases. The legislature, the whole issue in McLean was whether this amendment to the Williams rule statute violated due process. And the court found that it hadn't, because the court has to conduct this weighing process, consider the factors, and the bottom line issue in McLean was whether the prejudice outweighed the probative value.
Doesn't McLean really set up a sort of a two-pronged test? First, there has to be clear and convincing evidence that the prior crime occurred.
Correct.
And then do the balancing test.
Right. I mean, it's the same, relevance and then probative value.
Well, it's the clear and convincing evidence that the prior crime occurred that is of interest to me.
Okay.
How do you go about assessing clear and convincing evidence when you're a trial judge making a determination like this?
I think just the same as any juror would in determining whether there's evidence beyond a reasonable doubt. I mean, here you have a victim who said, I am 100% sure that this man came into my room 3 times one night and fondled my genitals.
Well, did he say that?
He said, I am 100% sure it was him. That's at, I believe, page 247 of the record.
Okay.
You also have the additional evidence of the other counselor who testified that he was gone for a long time. He did wear the same hat. And when he saw him, he said he had been checking on the boys, so he clearly put himself right with the children at the camp. And also, he did not have a flashlight, which the other counselor said whenever we went to check on the kids, we always carried a flashlight so we could see them because it was dark and there were coverings on the windows.
Did the trial judge make an express finding of clear and convincing evidence?
I don't believe he did, no.
No, because he didn't have the crime at the time.
Correct.
Did the trial judge in McLean make an express finding of clear and convincing evidence?
I don't believe he did, no. No, that was...
Is that an issue that we can address as a matter of law?
I think this court can, yeah. I mean, this would be a pipeline case. McLean did come out while this case is pending. And, yeah.
Well, the Supreme Court must have in McLean, because they didn't send it back for the trial judge to make that finding, did they?
No.
There was no corroboration of the act itself, was there, other than the alleged victim's testimony?
In the prior act?
Prior act.
The victim's testimony and then the circumstantial of the other counselor saying that he had been gone and said he was checking on the children.
Okay, and there was no positive identification of this defendant at the time?
Except the victim said, I am 100% sure it was him.
Not because he recognized him, though, right?
Well, he said he recognized the hat. He said he always had that hat on. And the other, I think the other counselor said he always wore that hat too. And interestingly, the defendant took the stand and said, I never wore that hat. So, I mean, either he wore the hat or he was up there flat out lying, saying, you know, I never wore that hat, I was not there. So I think that the defense that he took to it too is further indication that it was him and that he wore the hat that night.
Let me ask you about the feature of the trial issue. Counsel's made that argument in his brief. That's nothing unique under Williams rule law. In other words, that didn't come out in McLean, right?
Correct.
So courts have evaluated whether something has been a feature of the trial as long as they've been evaluating Williams rule evidence, right?
Correct.
All right. Now, is the focus there on how much time is spent on the collateral crime in total, or how much time is spent on that issue by the government, or something in between? I mean, what is the analysis there?
I think first I would look at how much time was spent on it by the government. I mean, are they trying him for this other crime, or are they trying him for the crime at issue? And if you can look at the record and say, no, it just came in for the express purposes under Williams rule, under collateral act evidence, then no, it can't become a feature of the trial then. I mean, here we have the victim testified. It was 3 pages. I mean, essentially, he came in, he did it 3 times, and that was it. The counselor came in and testified that he saw him in the hall, and that was it. It was not dwelt upon.
I'm not sure I understand what the intervening circumstances element is of the McLean test. Do you have a handle on that at all?
No, I'm sorry, I don't, Your Honor. I mean, maybe if they had gone to trial on the other one and been acquitted or something, something like that. But
There doesn't seem to be a difference between this case and McLean as it relates to that element.
correct.
If anything, the 14-year time span between the charged and uncharged crime in McLean suggests that the intervening element should apply because of the passage of time.
Correct.
Okay.
Correct. And I mean, that's been true with a number of child molestation cases, and I believe it was Herring that set forth, you know, that these things only happen generationally, which, you know, when it's in a familial aspect, but it's, I mean, these people, they're opportunists. When they get the opportunity, they do it. It's not something that, you know, and a lot of times crimes aren't reported, too. I mean, this man could have been molesting other children, but no one else reported.
Counsel's final point had to do with the fact that this evidence was used as propensity evidence, which, you know, runs against everything we ever learned about the Williams law, but that's the whole point of the statute, right? They can use it for propensity now,
Yes.
right?
Yes. And I mean, propensity and opportunity are very similar too. It's a fine line to draw. So.
Well, I think Justice Pariente said it was used to corroborate the testimony of the victim. That's propensity evidence, isn't it?
Yes, it is, and that has been the huge leap that's been made in the child molestation cases. So, but I mean, under the law, as it stands, it's the state's position that the trial court did not abuse its discretion in admitting this testimony. It had a hearing like it was supposed to. The trial court weighed the factors and determined that it was admissible, and so the state would ask this court to affirm the judgment and sentence of the trial court.
Well, let me just ask you, I'm still troubled by this clear and convincing evidence thing. Doesn't the trial judge have to hear the testimony at this hearing in order to determine whether there's clear and convincing evidence in order to allow it to be offered at trial?
I think that if there's no dispute at the hearing below, if the state proffers, I believe in this instance they proffered the police report of the original incident. If I'm wrong, correct me. But I believe that's what happened. And I think if that's the facts that the state is going to present, then I think that's sufficient. Just like a court can tell on direct review, I mean, from the record, like when this court's reviewing judgment of acquittal, you can look at the facts that were presented at trial and determine whether there was sufficient evidence or not. So I
But
think
here, in this case, all we had was a police report. We didn't even have a prosecution. The guy was never even charged. All you
Correct.
had was a police report of an alleged prior incident. In order to serve the function of the gatekeeper under the McLean test, doesn't the court actually have to hear that testimony? I mean, this is a case where all you had was the testimony of the child saying it happened, and I'm sure the guy did it because he was the only one who wore the cap. I didn't see the guy, no matter how many, 3 times that he was supposedly in there?
yes.
He was in there 3 times. I never saw him. I couldn't identify the guy, but I could identify the hat. Doesn't the trial judge have a duty to listen to that testimony and determine the credibility of it in order to be able to say that there's clear and convincing evidence that this crime occurred and the jury will be allowed to hear it in this case?
Well, I think at a pretrial hearing, if there's not a dispute as to this is the evidence that the state is going to present, then I think it's
But the trial
sufficient for...
court can't assess the convincing nature of the evidence.
Well, Your Honor, then I think perhaps maybe the state would run the risk if then they proceed to trial and present this and the judge says, whoa, this witness is totally incredible, I'm declaring a mistrial right now. I was wrong in saying that this evidence should have been admitted. But I think that the court can make that determination pre-trial. And even at trial, the defense can say, Your Honor, this was not clear and convincing evidence. It should never have come in, so I move for a mistrial.
Is there any rule of law that says that the gatekeeping function has to be performed pre-trial?
No, there isn't.
In this case, it was the defense that filed a motion to exclude the evidence pre-trial, and the judge heard the defense motion. Is that right?
Correct.
Who would have had the burden at that point in time?
The defense.
Well, I thought this was the state's motion to admit similar fact evidence.
And then I think the defense filed a motion to exclude it.
Well, so we had both motions
Right.
to be heard.
I think the state served a notice of intent to use similar fact evidence.
Right.
To which the defense responded with a motion to exclude. Is that right?
Right. And then the state filed a memo supporting it, and then the trial court had a hearing. So, I mean, the evidence was before the trial court, what the state was going to present, so.
Could you comment on the defense position that the facts were not that similar? They were significantly different in the two?
I think they were almost identical. I mean, you have a man who is in somewhat of a custodial position over children. As a matter of fact, he met this victim when he was, I mean, they were even talked that he was a counselor at the summer camp at the Jewish Community Center. So he has the opportunity. He fondles their genitals. The only, I mean, one was 6, one was 13, but I mean, they were both boys, so it's even that is not that big of a distinction. I mean, I think these crimes are virtually identical.
Thank you, Counsel.
Okay, thank you.
Mr. Keogh, I'll give you 2 minutes if you think you need it.
Appreciate it. A couple of things. The focus on the clear and convincing. First of all, I agree with Ms. Nealon's thing about how this came up and the evidence. The evidence was the police report. In my motion in limine to exclude it, I had a chart pretty much laying out side by side the allegations. There was no dispute at that point in time of what the evidence was going to show, and essentially the evidence at trial pretty much mirrored that. But as far as clear and convincing, Judge Torpy early on asked me about is that enough to get it to a jury in a typical case. Yeah, but thinking about it, at that point in time, getting it to a jury, it's a prima facie case. A judge isn't making a determination, is there clear and convincing evidence? Is there enough evidence here to support a charge? But he's not being asked at that point in time, is there clear and convincing evidence of this? Am I, as a finder of fact, being asked, is there clear and convincing evidence that this collateral act occurred? He's not being asked if he personally believes that a collateral act occurred, and he's not making that finding of fact at that point in time. What he's saying is it enough to allow these other 6 people that are our jury determine in a typical case whether or not the defendant's guilty of the crime? Here, of course, he's never charged with it and all of that. I don't believe that this evidence meets a clear and convincing standard that a judge could say that I'm convinced that this crime, number one, occurred, and number two, that the defendant, who is identified by a hat and, yes, circumstantially, is the person that did it. And I believe that that's a fundamental flaw in this case. I won't reiterate the probativity, relevance versus probativity test, since we did it before. But one last thing is the jury instruction. You talk about this evidence, it's actually propensity evidence, but it's really allowed in to corroborate the child's testimony. If you look at that jury instruction, that's not in that jury instruction. This evidence, the judge said, can be considered for plan, absence of mistake.
He used the standard instruction, right? Essentially with one modification. He took out identity, and he added the part you wanted him to add in there about his
It's not on trial. But he did not include the language from the, what would be the pre-trial, not the pre-trial, in-trial collateral act instruction, that you can consider it to corroborate so-and-so's testimony. Thank you.
Thank you, counsel.